Jehovah's Witnesses give an official response to the legal case involving Deborah Hines. Kings County Clerk, February the 14th, 2022. Supreme Court of the State of New York, County of Kings. The plaintiff in this case is a former Bethelite by the name of Deborah Hines. The defendant, Watchtower Bible and Tract Society of New York, Incorporated, the governing body of Jehovah's Witnesses, and John and Jane Doe's 1 to 10 as priests, clergy, staff, and administrators whose identities are unknown to plaintiff. The index number is 520772. Defendant, Watchtower Bible and Tract Society of New York, Incorporated, answers to the plaintiff's complaint with affirmative defenses. Defendant, Watchtower Bible and Tract Society of New York, Incorporated. Defendant, by way of answer to plaintiff Deborah Hines, plaintiff complaint says as follows. When it comes to the parties, paragraph 1, defendant lacks knowledge or information sufficient to form a belief to the truth of the allegations of paragraph 1 at this time and therefore denies the same. Paragraph 2, defendant lacks knowledge or information sufficient to form belief of the truth of the allegations of paragraph 2 at this time and therefore denies the same. The defendant, Watchtower, continues to deny most claims. Starting in paragraph 3, defendant admits the allegations of paragraph 3. Paragraph 4, defendant denies the allegations of paragraph 4, and they also deny paragraph 5, 6, 7, 8, 9, all the way up to 20. Defendant denies the allegations in paragraph 20. Other relevant entities, paragraph 21, the defendant denies all allegations of paragraph 21. They deny all allegations up to paragraph 26. And now we enter the background of the case. The defendant denies all allegations of paragraph 27. The defendant continues to deny all the allegations all the way up to now we're at 54. Defendant denies the allegations in paragraph 54. The defendant, Watchtower, continues to deny all the way up to paragraph 98. Defendant denies the allegations of paragraph 98. The defendant, Watchtower, continues to deny all the allegations all the way up to paragraph 129. The defendant denies all the allegations of paragraph 129. The defendant continues to deny all the allegations up to paragraph 154. Defendant denies all allegations of paragraph 154. Now we're at the jurisdiction and venue. Paragraph 155, the defendant denies the allegations of paragraph 155 up to paragraph 157. As far as the background facts related to the plaintiff, which is Deborah Hines, paragraph 158, the defendant denies the allegations of paragraph 158. They deny the allegations all the way up to 161. And now we'll take a look at paragraph 162. Defendant lacks knowledge or information sufficient to form a belief as to the truth of the allegations in paragraph 162 at this time and therefore denies the same. Paragraph 163. Defendant lacks knowledge or information sufficient to form a belief of the truth of allegations of paragraph 163 at this time and therefore denies the same. Defendant denies 164, 165, 166. The defendant lacks knowledge or information sufficient to form a belief of the truth of the allegations of paragraph 166 at this time, therefore denies the same. They deny all the way up to 181. Defendant denies allegations in 181. Now, cause of action against defendant, negligent supervision. Paragraph 182, defendant repeats and realleges all aforementioned responses as if fully incorporated herein. And Watchtower again denies all allegations of 183, all the way up now to paragraph 200. Defendant denies the allegations of paragraph 200. Now we're at paragraph 201. Defendant denies the allegations of paragraph 201. Wherefore, defendant demands judgment in its favor and against plaintiff, denying plaintiff's claim with prejudice and awarding defendant such other and further relief as the court deems just and appropriate. So basically, they're asking for the case to be denied. Now, under negligent retention, paragraph 202, defendant repeats and realleges all aforementioned responses as if fully incorporated herein. The defendant Watchtower denies all allegations of 203 all the way up to 211. Wherefore, defendant demands judgment in its favor and against plaintiff, denying plaintiff's claim with prejudice and awarding defendant such other and further relief as the court deems just and appropriate. Now we're at count 3, negligent failure to train relating to child abuse. Paragraph 212, defendant repeats and realleges all aforementioned responses as if fully incorporated herein. Paragraph 213, the defendant denies the allegations of paragraph 213. The defendant Watchtower continues to deny all the paragraphs up into paragraph 220. Defendant denies allegations in paragraph 220. And again, wherefore, defendant demands judgment in his favor and against plaintiff, denying plaintiff's claim with prejudice and awarding defendant such other and further relief as the court deems just and appropriate. When it comes to negligent undertaking, again, the defendant is denying all the claims. And again, they ask for this to be denied. Wherefore, defendant demands judgment in favor and against plaintiff, denying plaintiff's claim with prejudice and awarding defendant such other and further relief as the court deems just and appropriate. And then intentional infliction and emotional distress, paragraph 232. And again, the defendant repeats and realleges all aforementioned responses as if fully incorporated herein. And again, they ask for this to be denied as before. When it comes to negligent failure to provide a safe and secure environment, in paragraph 241, again, the defendant is asking that all the allegations be denied all the way up until paragraph 255, and again they ask that the case be denied to the plaintiff. When it comes to sexual abuse and battery, again, the defendant repeats and realleges all aforementioned responses as if fully incorporated herein, and again they're asking for all these allegations to be denied up into paragraph 266. And again, they're asking for the plaintiff's case to be denied. When it comes to negligence, it's the same thing. They deny. Watchtower denies. And then they ask to have the case denied again. So now we get into the meat of it. Affirmative defenses. By alleging the affirmative defenses set forth below, defendant does not allege or admit that it has the burden of proof and or the burden of persuasion with respect to any of these matters. First affirmative defense, the complaint fails to state a cause of action against defendant. Second affirmative defense, if plaintiff has sustained damages or alleged in the complaint, which defendant denies, plaintiff claims are barred or reduced in whole or in part by the doctrines of contributory and comparative negligence. Third affirmative defense. If plaintiff have suffered any injury or incurred any damages, which defendant denies, that injury or damage was caused in whole or in part by, number one, the acts or omissions of persons other than defendant or over whom defendant had no control, or 2, superseding intervening causes over the defendant had no control. Fourth affirmative defense, defendant owed no duty to care toward plaintiff. Now keep in mind she was a minor. Fifth affirmative defense, the injuries, damages, or losses, if any, sustained by the plaintiff were not reasonably foreseeable and were not the result of any conduct or negligence by defendant. Sixth affirmative defense, plaintiff has failed to mitigate the damage, if any, that plaintiff has allegedly sustained to the exercise reasonable care to avoid the consequences of harms, if any, by, among other things, failing to use reasonable diligence, failing to use reasonable means to prevent aggravation of any injury, and failing to take reasonable precautions to reduce the injury and damage. The seventh affirmative defense, plaintiff's alleged damages, losses, and or injuries were not proximately caused by any act or omission of the defendant. Eighth affirmative defense, plaintiff's claims are barred in whole or in part by applicable statutes of limitations and or repose. Ninth affirmative defense, plaintiff claims are barred in whole or in part by the doctrine of estoppel, collateral estoppel, laches, and or waiver. Tenth affirmative defense, defendant denies any negligence because, at all times relevant to the complaint, defendant met or exceeded the requisite standard of care. 11th affirmative defense, defendant acted reasonably and in good faith based on all relevant facts and circumstances known by the defendant at the time they so acted. 12th affirmative defense, any injuries plaintiff sustained are the result of an unforeseeable series of events over which defendant had no control. 13th affirmative defense, if plaintiff have sustained damages or alleged in the complaint, which defendant denies, plaintiff damages were the result of plaintiff's unforeseeable pre-existing medical conditions or other medical conditions for which defendant cannot be held responsible. Okay, so Watchtower 14th affirmative defense. Plaintiff's claims are barred by the doctrines of res judicata and or collateral estoppel. 15th affirmative defense. Defendant is entitled to offset and or reduction and plaintiff barred from recovering any and all amounts paid for plaintiff's alleged injuries and damages by way of settlement or judgment of any claim, incident, or lawsuit which may have contributed to the injuries and damages referred to in the complaint, in the event defendant should be found liable to plaintiff, although this supposition is denied and only stated for the purposes of this affirmative defense. 16th affirmative defense. Plaintiff's claim for punitive or exemplary damages fails to state a claim upon which relief can be granted. 17th affirmative defense. To the extent plaintiff seeks recovery of punitive and exemplary damages against defendant, unless defendant liability of punitive damages and the appropriate amount of punitive damages is required to be established by clear and convincing evidence, any award of punitive damages would violate defendant's due process protections afforded by the United States Constitution, the excessive fines clause of the Eighth Amendment of the United States Constitution, the Commerce Clause of the United States Constitution, the full faith and credit clause of the United States Constitution, rights guaranteed by the 14th Amendment to the United States Constitution and by the applicable state constitution, and would be improper under the common law and public policies of the state. Any law, statute, or other authority purporting to permit the recovery of punitive damages in this case is unconstitutional, facially, and applied to the extent that, without limitation, it, number one, lacks constitutionally sufficient standards to guide and restrain the jury discretion in determining whether an award punitive damages and or of the amount, if any. Number two, is void of vagueness, both facially and as applied, because it fails to provide adequate advance notice as to what conduct will result in punitive damages or what punishment will be imposed. Number three, unconstitutionally may permit recovery of punitive damages based on the out-of-state conduct that complied with the applicable law, or conduct that was not directed at plaintiff or did not proximately cause harm, if any, to plaintiff. Number four, unconstitutionally may permit recovery of punitive damages in the amount that is not both reasonable and proportionate to the amount of harm, if any, to plaintiff and to the amount of compensatory damages, if any. Number five, unconstitutionally may permit jury consideration of net worth or other financial information regarding the defendant. Number six, is not subject to adequate trial court and appellate judicial review by reasonableness in furtherance of legitimate purposes on the basis of the objective standards. Number seven, lacks constitutionally sufficient standards for appellate review of the punitive damages awards, and number eight, otherwise fails to satisfy Supreme Court precedent, including without limitation, Pacific Mutual Life Insurance, and so forth. 18th, affirmative defense. To the extent plaintiff seeks recovery of punitive and exemplary damages against defendant, any such claim of plaintiff for punitive damages against defendant cannot be maintained, because an award of punitive damages under applicable law would also be unlawful as a result of, among the deficiencies, the absence of a predetermined limit, such as a maximum multiple of compensatory damages or the maximum amount, on the amount of the punitive damages that a jury may impose, all in violation of due process clause of the 14th Amendment to the United States Constitution, the applicable state constitution, and the common law and the public policies of the state. Watchtower 19th, affirmative defense. To the extent plaintiff seeks recovery of punitive and exemplary damages against defendant, any such claim of plaintiff for punitive damages against defendant cannot be maintained, because any award of punitive damages under applicable law would be a jury that, number one, is not provided standards of sufficient clarity for determining the appropriateness and the appropriate size of a punitive damage award. Number two, is not adequately instructed on the limits of punitive damages imposed by the applicable principles of deterrence and punishment. Number three, is not expressly prohibited from awarding punitive damages or determining the amount of an award of punitive damages in the whole or in part on the basis of invidiously discriminatory characteristics, including the residence, wealth, and corporate status of defendant, and number four, is permitted to award punitive damages under a standard for determining liability for punitive damages that is vague and arbitrary and does not define the sufficient clarity of the conduct or mental state that makes punitive damages permissible. As such verdict would violate defendant's due process rights guaranteed by the 14th Amendment to the United States Constitution and by the due process and equal protection provisions and the applicable state constitution, and would be improper under the common law and public policies of that state. Watchtower's 20th affirmative defense. To the extent that the complaint seeks punitive and exemplary damages, the Due Process Clause of the United States Constitution must govern any award of punitive and exemplary damages, and the purported profits of the defendant outside the state of New York may not be brought into consideration. First, affirmative defense. To the extent that the complaint seeks punitive and exemplary damages, plaintiff's claims are barred in whole or in part because punitive or other exemplary damages are not recoverable for the causes of action set forth in the complaint, or in the alternative, the allegations of each cause of action in the complaint are legally insufficient to support a claim for punitive or exemplary damages as to each cause of action. 22nd Affirmative Defense. To the extent that the complaint seeks punitive and exemplary damages, plaintiff's claims are barred in whole or in part because defendant did not act with the requisite level of conduct to be subjected to, or that would otherwise support any punitive or exemplary damages award in this action. Accordingly, any award of punitive or exemplary damages would be improper under the United States Constitution and the common law and public policies of New York. 23rd Affirmative Defense. The complaint is barred because plaintiff lacks standing. 24th Affirmative Defense. If and only if plaintiff's allegations are accurate, then defendant asserts its entitlements to an apportionment of fault by the trier of fact between any person, legal or natural, to whom apportionment of fault may be made under statutory and common law principles. 25th Affirmative Defense. Plaintiff's claims are barred by the doctrine of charitable immunity and or the Free Exercise Clause of Establishment Clause of the First Amendment of the United States Constitution. 26th Affirmative Defense. The complaint is barred because the New York Child Victims Act, CPLR 214G, violates the Due Process Clause of the New York State Constitution on its face and as applied to defendant. 28th Affirmative Defense. Defendant adopts and incorporates by reference in this answer any defenses that may be raised by any other defendant who may be joined to this action. Defendant further gives notice that they intend to rely on any additional defenses that become available or apparent during discovery, and thus reserve the right to amend this answer to assert any additional defenses. Designation of trial counsel. Defendant hereby designates Anthony P. LaRocco as trial counsel. This was dated February 14th, 2022. Respectfully submitted by Anthony P. LaRocco. And if you notice here, they're being represented by K&L Gates LLP, 1 Newark Center, 10th floor, Newark, New Jersey. And it says, attorneys for defendant, Watchtower Bible and Tract Society. So this must be costing them money.